the Sierra Raymerman needs to talk to the provisional attorney.
Potentially, yes.
So let's bring Ms. Raymerman into the courtroom, and then we'll put her in a breakout room for Raymond to.
She's here. I believe she was going to be appearing in person. She was the one
She changed her mind.
I believe it was. So I can schedule that hearing.
Probation to, because I think she's in Arizona.
Okay. Would you like me to admit Ms. Oren then?
Yes, I mean, Ms. Rodriguez. Let her know that she's muted. I think you need to turn that volume off. All right, Ms. Oren, your mic is muted, so can you hear me? All right, Ms. Oren, we're here today on Pasco Municipal Court. It's 9:14. You're appearing remotely on your case. Is Roxana Franco present? Ms. Franco, why don't you come forward to this table with the microphone, please? In the courtroom with me this morning is Mr. Hanson, as well as the clerks. Ms. Franco is appearing in person on this matter. What are we doing today, counsel?
Well, Your Honor, the city's moving to revoke the deferred prosecution. Probation does have the notes on why. I believe there's failure to attend victims panel, as well as consumption and use in violation of deferred prosecution.
And Ms. Oren, can you hear? Did we lose you? Ms. Oren? Ms. Oren, are you able to hear us?
Good morning, Judge. I can barely hear you.
All right, I don't know why that is the case. We keep losing your video. Now we've lost you all together. Do we have any other attorneys? Is Ms. Bennett's client appearing remotely as well? Ms. Franco, go ahead and have a seat. It seems that Ms. Oren's had some technical difficulties and we've lost her. She's disconnected. All right, Ms. Bennett, can you hear me?
Yes, Your Honor.
All right, and typically with these Zoom meetings, individual or attorneys are required to appear by video. Are you not appearing by video today?
Let me see. I'm sorry, I'm new at this. Let me see if I can figure that out.
And is your client with you?
He's not with me, but he says he's on Zoom. It says, please wait till meeting starts.
All right, so Christian Smith,
Yes.
do you have?
I don't have a Smith. I have a Galaxy phone, 2 iPhones, and a phone number.
All right, they are, individuals are not identifying themselves. So you might want to send a message to them that they need to identify themselves. So
I
we,
can do that.
yeah.
Okay, let me do that right now.
See what responses yet. Perhaps we should include that in our instructions. Would you like me to admit them one at a time and just see which one is Mr. Smith?
Yeah, I suppose so. Or bring them all in. We can tell them that they need to change their phone number or their phone identification to their name so we know how to.
He says he has an iPhone. He says, I just created the account. Oh, is this?
All right, good morning, each of you. You're appearing in court today, but each of you are identifying just indicating either an iPhone or the type of Galaxy phone. You need to replace that with your actual name so that when we're ready to call your case, we know how to identify you. So if you can take a moment to do that, we're going to place you back in the waiting room. And when you've identified yourself and your attorney is ready, we'll bring you back into the courtroom. And be sure you pay attention as to whether or not your phone is muted or unmuted when you enter the courtroom. Okay? So go ahead and identify yourself, gentlemen, and accomplish that. We'll place you back in the waiting room and we'll see you momentarily. Also, has anybody identified themselves?
No, just Mr. Sorto, who originally had already been identified.
Yes.
Rodriguez's client. I seem to have lost the iPhones. Galaxy and now we have Mr. Camacho, who's Ms. Rodriguez's client. I'm still not seeing Ms. Bennett's client. I did make a co-host, so you should be able to see good.
I can see some of those individuals, yeah. And Mr. Huey, there's one other individual who's appearing, I believe, remotely from out of state that's appearing on a warrant on a probation violation. But I don't see that they've actually logged in yet, so we'll see. No, it's this file here. Ms. Bennett, unfortunately, your client's not identifying himself. We don't know who he is. It looks like he's left the waiting room as well.
Okay. I can text him, or I could call him on the phone and put him on speaker.
No, he needs to appear remotely via the Zoom. It's one of the requirements here.
It's hitting this orange, turn the light back on.
He says he's on. He says, I'm here.
Is he the one using the Galaxy phone?
He said he had an iPhone.
There is no one in the waiting room with that's identified as an iPhone or has replaced their phone identification with their name.
Okay. I'm letting him know, maybe log off and try again.
Yeah, whenever it's ready to. Ready to go. Christmas, there we go.
He says he's in the waiting room. I'll ask him if he logged off and logged back in.
I think we have him now.
Okay.
All right, and you are Christian Smith? You need to unmute your phone.
Yes, sir.
Right, there you go. Ms. Bennett is present as well. This Pasco Municipal Court, we're here today for a pretrial hearing. What are we doing today, Ms. Bennett?
Your Honor, I think we'll need to set a trial date and pretrial date today. We are hoping that, we'll be, if we set it far enough, we'll be in a time frame where we won't have to risk a Zoom trial. So I would just request a date that would be realistic for that, for trial and pretrial. And I can defer to the city if they have any preference with date.
And I would say for the benefit of counsel and Mr. Smith, that yesterday I received a copy of an order signed by the Superior Court presiding judge indicating there will be no trials or jurors summoned through the month of September. Realistically, the date that I heard them talking about is after the first of the year. Although apparently they're going to proceed month by month and make a determination about whether or not they will summons jurors in or not. I think there's a copy of the order posted to the Superior Court website that basically makes a finding that a number of jurors have expressed concern about COVID-19 and appearing for a trial. And based on the information provided by the Department of Health, the concerns of the jurors, the presiding judge has elected not to summons any jurors while this, at least through September. So I can't tell you for certain which when the Superior Court will begin to summons potential jurors for a trial, but they suggested not before January, so it may make some sense to set this in January.
And Your Honor, that's my understanding. I was aware of the order in Superior Court for realistic, not wanting to bounce court dates again and again and again. The city would suggest January 15th for a trial readiness date and January 20th for a trial date if that works for Ms. Bennett and her client.
And Ms. Bennett, are you able to hear Mr. Hanson? He's suggesting a January 15th trial readiness and a January 20th trial date.
Yes, what time would the hearing on the 15th be?
That would be at 8:45.
Okay. And if we're still doing by Zoom, I guess I'll just file that request a little, maybe in December with the court's permission.
Yes.
Okay, thank you.
Sure, I guess, is Ms. Bennett agreeing to a waiver of the trials, the polling stops in September, at least for the time being?
I am I'm making a finding, and I'll be entering an order in this court as well, that based on the Superior Court's order postponing any jury trials, of finding good cause, that the time for a speedy trial currently, which was to begin again on September 2nd, now is told through September 30th.
Your Honor, if we could have a proposed discovery cutoff date of December 18th on this.
That's fine.
We'll set a discovery cutoff date as well of this. Did you say the 18th, Mr. Hanson? December 18th. And so we're all on the same page, Ms. Bennett. You're agreeing to the reset, is that correct?
Yes, that's our request. Thank you.
Thank you. We have a waiver form. We might as well just fill it out and send everybody a copy of that. All right, so we'll give a discovery cutoff date of December 18th, a trial readiness of January 15th. On January 15th, that time is at set for 8:45. Trial is set at 8:30 on January 20th. We'll prepare a notice and forward that to you, Ms. Bennett. You can forward that to your client. All right.
Thank you.
All right. If there are no other issues, that will conclude this hearing, and you are free to go.
Thank you.
All right, we have, did Ms. Oren ever make it back?
Yes, Your Honor.
Yes. All right, good morning, Ms. Oren. Can you hear me? And your microphone is muted.
Okay, I'm unmuted.
All right, there you go. This Pasco Municipal Court, Ms. Franco is present. We did begin this hearing, and Ms. Oren had some technical difficulties and has logged back in and is now present remotely. Mr. Hansen is in the courtroom with us as well. The city has made a motion to revoke the deferred prosecution in this case based on a failure to attend the Victims Impact Panel and a report of use of both methamphetamine and alcohol and non-compliance with the treatment program. If probation has any additional information to provide in support of that motion, you can do that now. Probation Officer Bastian is present in the courtroom as well.
Good morning, Your Honor. So it looks like we did receive a report on July 6th indicating that defendant's level of care has increased to level 2.1, and probation is recommending to revoke the deferred prosecution today due to her relapse, and at this point she should have been done with the deferred. And once again, just in level of care.
All right, so just to recap, the 2-year review date for the deferred prosecution treatment was June 9th, 2020. And at this point, Ms. Franco has now started treatment again at a higher level than that was previously, at which she was previously engaged. The city is moving to revoke the deferred prosecution. Ms. Oren?
Yes, it asks the court not to do that. I think if you look in the file, you'll see my client's a veteran. She suffers from some other issues in addition to her substance abuse. She is back in compliance, and as the court noted, I think the treatment is up to 3 times per week. And my client reported to me that she did take the victims panel. I don't know where the proof of that went. I believe she gave that to probation, but they don't have it. So we could get, some of this is frustrated, the process through COVID. We'd ask that you not revoke her, that you give her another opportunity to complete. Of course, if she does it this time, I think she knows that what the consequences to her are of that.
All right. Thank you. And I will say that this issue was addressed in December 2018 when she entered the deferred prosecution. Right at the 6-month review date, there were issues with her attendance and her compliance with the program. She was ordered to additional treatment with a co-occurring treatment and authorization. Later in March 2019, there were continued issues and ongoing problems. However, probation struck the hearing at that time indicating that she was out of state and they would monitor the program. Here we are now 2.5 months after the time frame for which she should have completed the 2-year program. I don't see that there is any possibility that within the current time frame of both completing 2 years of treatment and an additional 3 years of probation following that, that there's any way she can successfully complete that deferred prosecution program. So based on the multiple issues of noncompliance with treatment, I will revoke the deferred prosecution today. Ms. Oren, are you prepared to proceed today to any type of stipulated facts, or do you want to talk to your client?
I'd like to speak to my client about that.
All right. You can reset this to, let's do this onto a Friday morning docket for a bench trial on reports.
How far up do it go, Your Honor?
Do you want to do that in September? Or do we have time in September?
Do it on the 4th or the 18th.
We can do it either on September 4th or September 18th.
How about the 4th?
All right.
We do have a pro tem judgment day.
Do you have any objection to a pro tem judge hearing the case, Ms. Oren?
Oh, that's fine.
All right. Shall we set this at 10 o'clock? Do you want to set it earlier, Mr.
We
Kelso?
have those set at 10 because they're remote hearings, so I don't know if we want to do this beforehand. If we set it for the normal 8:45, we can get it done before.
We'll probably do it remotely at, Ms. Oren, you're asking that you appear remotely, is that correct?
Yes, please.
So we'll set that at 10 a.m. Ms. Frankel, we'll give you a copy of this order today. You are required to be here on September 4th at 10 o'clock in the morning. Meet with Ms. Oren before that date. And that will conclude our hearing today.
All right, thank you.
All right, thank you, Ms. Oren. You're welcome. All right. And we are. Here's Mr. Smith. And Ms. Rodriguez. I'm going to admit her in the. Let's see if she is.
They also have N Rodriguez right underneath that. I don't know.
I see that.
On a different device.
Good morning, Your Honor.
Good morning, Ms. Rodriguez. I see you're having a little bit of a difficulty. You're not alone this morning. So this Pasco Municipal Court, Ms. Rodriguez, I think we have 2 of your clients so far ready remotely. We do not have an interpreter yet, but we can take those cases that you are ready to go on that don't need the interpreter. Do you have a preference?
No, Your Honor. Any way you want to call him, that's easier.
Mr. Camacho is named himself in this
All right, I see that Mr. Camacho is present, so I'm going to go ahead and admit him. You've had an opportunity to talk to him. Are you ready to go, Council?
We are, Your Honor.
All right,
On Mr. Camacho, we do have an offer that Mr. Camacho is going to take, so we'd like to set this on to the next available date so that we can prepare the paperwork and get that done.
all right. And good morning, Mr. Camacho. Your microphone is muted right now, so if you can unmute that so you can participate in the hearing. Are we able to hear Ms. Rodriguez's comments?
Mm.
Was
Yes.
that-
Yeah.
All right. And is this a hearing at which you'll appear in person, Ms. Rodriguez?
No, Your Honor, can we have that telephonic, please?
Yes. All right.
And how are we doing the pleas on that, Your Honor? Are those electronic as well, or do I just provide those to Mr. Rio?
You can do those either way. You can, it would probably at this point be better if you communicated directly with Mr. Rio and came to an agreement, and because he's either submitting those electronically or he's bringing those to court.
Okay.
Okay. And let's see. Another, doesn't matter to me if it's a Wednesday or a Friday, either one.
As soon as next Wednesday, if they'd like. The 4th, we've got 3 remote hearings so far.
All right. Do you want to do this next Wednesday, Ms. Rodriguez, the 2nd, or do you want a little more time?
That would be fine, Your Honor. We just need to prepare a plea form. It shouldn't take too long.
So we'll set this for September 2nd for entry of a plea.
Is that at 9 a.m.?
It is at 9, yes.
Okay. Thank you, Your Honor.
All right. Thank you, Mr. Camacho. You are free to leave.
All right. Thank you.
You're welcome. And Ms. Rodriguez, which other client does not need the assistance of an interpreter?
Mr. Medina does not need the interpreter, Your Honor. Is he the one that's on? I can't see on my,
Or somebody has not identified themselves, so the only thing I have is a phone number or a phone identified as a Galaxy A21.
I'm not sure if that's Mr. Sorto or not.
Mr. Sorto has actually identified himself on the screen, so I'm going to admit the Galaxy and we'll talk to that individual, see who that is. All right, I've admitted into the courtroom an individual just identified by the brand of phone, the Galaxy A21. Can you identify yourself, please, sir? Are you Cesar Medina? The individual using the Galaxy A21 phone, are you Mr. Medina?
Oh, I just saw a picture.
And they just
He's having difficulty.
Did you see the picture, Ms.?
I-
Was that
I-
Ms. Medina?
Yeah, it was so quick, Your Honor. I couldn't tell, and I haven't seen
Oh.
Mr. Medina in years, so.
All right. Good morning. Sir, you do not have a name posted for your appearance. Are you Mr. Medina?
I wonder if he can't hear. Oh, connecting audio. There we go. Looks like it's connected.
Can you
Are
guys
you
hear me?
Mr.
All right, are you Mr. Medina, sir?
Yes, Your Honor. Yeah, I apologize. I couldn't figure it out.
Yeah, and your phone only identifies as the name of the Galaxy phone, not your individual, but we have you now. Ms. Rodriguez is present virtually as well. We're here today for a
Pre-trial, Your Honor.
pretrial hearing.
Your Honor, I did also speak to Mr. Rio about this. I did get a pretty good offer last night. I have not communicated that to Mr. Medina. So if we could also continue this matter, I'll relay that offer to Mr. Medina and see if he's interested in accepting it.
All right, and do you want to set this over to the second as well?
Yes, please.
All right. So, Mr. Medina, you'll need to meet with Ms. Rodriguez before this next court date, which is September 2nd. That's 1 week for another remote hearing. When you come back, please replace the name of your phone, and you do that by, well, I don't know if you do it by tapping on that, but you can replace that with your name so we can identify you when you come into the waiting room and we know who the individuals are, okay?
Okay, Your Honor.
So we'll continue this 1 week for pretrial at your request, Ms. Rodriguez.
Thank you, Your Honor.
Yes, so that's without notice, Ms. Rodriguez. All right, Mr. Medina, thank you. You're excused this morning. You're free to go.
All right. Thank you, Your Honor. Apologize for the inconvenience.
No, that's all right. Thank you.
Thank you. Bye.
All right, Ms. Rodriguez, we can place you back in the waiting room until we have an interpreter
Oh,
and we're ready to,
where's my camera?
and we're ready to call your case.
All right, Your Honor. Thank you.
Thank you, Ms. Rodriguez. Is the Arizona maybe? All right, I can, let's bring that individual into the courtroom and I'll talk to her. Good morning. Can you hear me okay?
Yes, I can hear you.
All right, you're only identified by a phone number on my screen. Is this Ms. Raymerman?
Yeah, I didn't know if you were talking to me, but I tried to look at the email and I was trying to figure it out, but I didn't want to hang up and you guys not think I was here. So I was unsure how to put my name on there. I put the passcode and everything in that it gave me.
There, we've replaced your phone number with your name. You are here today on a probation violation. You do have a right to be represented by an attorney. If you can't afford one, one would be appointed to represent you. I do have Mr. Huey today, the provisional attorney, because you're appearing first on this. What we're going to do is place you into what's called a breakout room, and you'll need to wait for Mr. Huey, and he'll speak to you about this case, and then you'll return to the courtroom. Okay? You just need to be patient.
Okay, thank you.
Stay in either the breakout room or the waiting room until we call your case and admit you into the courtroom. Okay?
Okay, thank you.
All right. So we need, are you ready on a couple of these, Mr. Huey?
There's one plea, the rest are conditions that I thought.
All right. We can take at least one of those. We'll take, I say a Rubio. This is cause number XE0658H24. So you're here today on a charge of simple assault, domestic violence. That is a gross misdemeanor. If convicted, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence. However, a conviction would result in the loss of your right to possess, own, or control a firearm unless your right is restored by a court of record. Do you understand that? You have a number of constitutional rights that were played before court started. Were you able to hear and understand those rights? Do you have any questions about those rights? You have had a chance to talk to the provisional attorney, Mr. Huey, today, and after doing so, you've indicated you wish to plead not guilty. I will enter a plea of not guilty on your behalf. You've also indicated that you will attempt to hire your own attorney. All right. I have reviewed the affidavit of probable cause. I do find probable cause in this case. Conditions of release.
Looks like he is previously convicted of assault, domestic violence back in 2000, so we have to make a finding he is ineligible to possess firearms while his no contact order is in place. It appears to have been his court dates on his 2017 cases, so city's not likely concerned about his ability to return to court. I think with the no contact order in place, that should provide sufficient security for the alleged victim, so the city has no objection with the argument.
No objection to that, Your Honor. We did talk about the no contact order. I think actually, in cases she does not reside at this location, and she's actually living in Seattle. He's always lived in Seattle, so he doesn't have an objection as long as there's no address for Pasco.
I'll not include the address on this one, just you do not understand, Mr. Rubio, under the conditions or the terms of this no contact order. You're not to knowingly enter, remain, or come within 500 feet of the protected person's residence, school, workplace, or her person. So even though there's not an address listed on here, wherever she is residing, you are restricted from entering or coming close to. Do you understand that? You're not to cause, attempt, or threaten to cause any bodily injury to, assault, sexual assault, harass, stalk, or keep under surveillance a protected person. Do not contact the protected person directly, indirectly, in person, or through others by phone, mail, or electronic means, except for the mailing or service of process of court documents through a third party or contact by your attorney. This is a pretrial temporary no contact order. It will expire on August 26, 2022. The court may extend this order if necessary. Only the court can change the order, and that's after a written request. A violation of this order with actual notice of its terms is a criminal offense under the RCW and will subject you to arrest. You can be arrested even if the person protected by this order invites or allows you to violate the order's prohibitions. Do you understand that, sir? All right. Based on that record this morning, I will release you on the following conditions. You're not to have any criminal violations or incidents. You're not to have any domestic violence related incidents. You're to obey the no contact order. Your next court date will be September 29th. At 8:30. You are required to, you hire an attorney, stay in touch with your attorney while this case is pending. We'll give you copies of these documents this morning. That'll conclude your case. You can have a seat. Felix Rosas. Go ahead and stand there where you are, Mr. Rosas. Good morning. You're here today on a charge of violation of other court order domestic violence. That is a gross misdemeanor. You have those same rights that I mentioned with Mr. Rubio. Do you have any questions about those rights? It's the same possible maximum sentence and results. That means if convicted of this, although there's no mandatory minimum sentence, you would lose your right to possess, own, or control a firearm unless your right is restored by a court of record. Do you understand that? I have reviewed the affidavit of probable cause. I do find probable cause in this case. Mr. Rosas, you have had a chance to talk to Mr. Huey. After doing so, you've indicated you wish to plead not guilty and request the court appoint an attorney in this matter. We will appoint Mr. Scott to represent you. Conditions of release.
Yes, there's no criminal law violations, make all future court dates, have no domestic incidents, obey all active no contact orders. Today's concern here is his ability to follow those conditions of release, as he is out on $500 bail on the Pasco County Sheriff no contact order violation, as well as $500 on the Richmond no contact order violation. Obviously, that financial incentive was not enough to prevent him from violating no contact order less than 2 weeks. This would be the third violation in 15 days. So the complete inability to follow a condition of release demonstrated 3 times thus far. The state's going to be asking for $10,000 factor bond to ensure you have no criminal law violations and you obey the Second County pretrial no contact order.
Mr. Huey.
Yeah, sure. I did go through the pending cases with each one of them. We did talk about how much bail he posted on those other cases. I guess the one good thing is there's no warrants on any of those cases, so it doesn't appear to be appearing or complying with the courts in Benton County.
Thank you. I'll take into consideration both his application for court-appointed counsel, criminal rule 3.2, looking at future appearance factors and showing a substantial danger factors. That second factor is a little bit misleading because you also include an individual's ability to follow the court's orders. You're released on conditions in 2 other cases in which you're ordered to abide by the no contact order. This is now the 3rd violation since August 10th. Some bail is appropriate here. We'll set that the amount of $5,000 cash or bond. If you post that bail, you're not to have any criminal violations or incidents. You're not to have any domestic violence related incidents. You're to obey the no contact order. You're to contact your attorney within 10 days and maintain contact with your attorney while this case is pending. Set this matter to September 14th. Excuse me. At 8:30, If you post that bail, as I indicated, you are to contact your attorney and maintain contact. That means contact them every week while this case is pending. Make appropriate appointments with your attorney in order to assist your attorney in this case. Be seated. Ryan Kelly. Mr. Kelly, you're here today on a charge of driving while license suspended in the 3rd degree. That is a misdemeanor. If convicted, you face up to 90 days in jail and a $1,000 fine. There is no mandatory minimum for such a conviction. Do you understand that, sir?
Yeah.
You do have a number of constitutional rights that were played before court started. Were you able to hear and understand those rights? You have had a chance to talk to Mr. Huey today, and after doing so, you've handed forward this statement of defendant on plea of guilty. This has some initials and a signature on this document. Did you place those initials and signature?
Yeah.
And does that indicate that you have discussed this case with Mr. Huey and have done this or are entering this plea voluntarily? There is a recommendation contained in this document. You understand I'm not required to follow that. If you plead guilty today, you do face up to 90 days. Has anybody made any promises or threats other than this recommendation to get you to plead guilty today? To the charge of driving a license suspended in the 3rd degree, a crime which was committed on or about May 20th, 2020 in the city of Pasco. How do you plead, sir? Guilty or not guilty? I think I said May 20th. I think that's the 28th, actually. Your statement is that on or about May 28th of 2020 in Pasco, Washington, I drove a car while my license was suspended in the 3rd degree. Is that a correct statement? I'll accept your plea of guilty. Fine, there's a factual basis for the plea. Is there anything you'd like to say, Mr. Kelly? Why didn't you come to court on this? Do you know what you need to do in order to get your license reinstated?
Yes, I'm actually gonna look into that.
All right. Are you working, Mr. Kelly?
No, I'm not right now.
How are you supporting yourself?
I'm not very much license.
When was the last time you did work?
Was in March.
Have you received any unemployment or anything like that? Well,
I'm in the middle of
and-
doing that, yeah,
I'm going to follow the recommendation. 2 days in jail with no days suspended. Credit for 1 day already served. That leaves a balance of 1 day. Considering your financial circumstances, impose a fine in the amount of $150. A $43 criminal conviction fee and a $102.50 traffic penalty assessment, a $100 jail assessment. Payments at $30 a month, begin those in October. Because you did plead to the criminal charge, I'm going to dismiss the infractions under cause number ending in 933. All right, we'll give you copies of these documents. That'll conclude your case here today. Kelly, you can have a seat. Sean Sylvester. Mr. Sylvester, you're here today on a charge of unlawful trespass in the first degree. That is a gross misdemeanor. If convicted, you face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for such a conviction. You do have a number of constitutional rights. Those rights were played before court started. Were you able to hear and understand those rights? Do you have any questions about those rights? You have had a chance to talk to Mr. Huey today, the provisional attorney. After doing so, you've indicated you wish to plead not guilty and request the court-appointed attorney. You do qualify. I'll appoint Mr. Libbert to represent you. Enter a plea of not guilty on your behalf. Conditions of release? Yes.
Yes, yeah, no law violations. Court case don't return to that property while this case is pending. Based on warrant issued previously on this case, so I want to history to address that self-defense on this court.
Yeah, sure. I look at the topic of this case. It's an unusual procedure. I think the officers put him into the jail, and the next notation is the jail. I don't know if he knows. He indicated that he didn't know about his next court date on August the 11th. I'm not sure what that process is for jail decided to release somebody. And can you tell whether he was given a court date on that time?
It looks like what happened is he was transported to jail and the jail staff requested medical clearance. And so rather than do that, the officer issued the citation and released him. But we have not been providing court dates on the citation. The clerk has been sending those.
Hoping he can be released and come back to court.
Mr. Sylvester, you do have some difficulty making your court dates, but you haven't been in trouble for a little while except for this, and then you have a couple of issues pending in Benton County as well. I'm going to give you the benefit of the doubt here, given the fact that you were released and that we didn't have a good address for you. We'll reset this to September 28th. You're released on the condition you have no criminal violations. You're not to return to this 820 North First address. Do you understand that? We'll give you a copy of these conditions of release as well as your attorney's contact information. You are required to contact your attorney within 10 days and maintain contact with your attorney while this case is pending. Make appropriate appointments with your attorney in order to assist him on this case. Do you understand that? All right. Levi Christensen. Christian, you're here today on a charge of simple assault, domestic violence. That is a gross misdemeanor. If convicted, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for such a conviction. However, a conviction would result in the loss of your right to possess, own, or control a firearm unless your right is restored by a court of record. Do you understand that? You do have a number of constitutional rights that were played before court started. Were you able to hear and understand those rights? Do you have any questions about those rights? I've reviewed the affidavit of probable cause. I do find probable cause. You have had a chance to talk to the provisional attorney today, and after doing so, you've indicated you wish to plead not guilty. We'll appoint Mr. Rutt to actually, I think, yeah. And I think Mr. Libbert is already on the prior case, so let's appoint Mr. Libbert on this one as well. So we'll appoint Mr. Libbert to represent on this case. Conditions of release.
Your Honor, so you have some no new criminal law violations, they call the court dates. Here exercising it was over alcohol consumption, so city has to consume no alcohol, marijuana, not prescribed without court cases pending. In this case, the victim was not requesting no contact order. However, this is the same victim from March 6th. So at this time, given the red circumstances, the same victim, at least that number of law violations. The city would ask that you issue that no contact order over the victim's request not to have them. That the city's concern here in this case that there's 2 assaults within 5 months of the same victim. So based on that, the city is going to request $5,000 capital bond in addition to no contact orders. Mr. Christensen has demonstrated to court in the ability not to assault his significant other.
Mr. Healy.
Correct. I did talk about the no contact order being raised. I just found in the PC states probably there's going to be a high probability that the issue is because it is a second violation in a very short time. You can talk about the relationship, why you don't want to do that. Tell the judge why you don't want it.
I understand how it may seem to the court, but in all honesty, I do love her and I don't want this to happen. She talked to me on the phone last night. She told me she wanted to see me as soon as possible. I think the show's a little too far. The mother of my child, we love each other. I'd do anything. I don't think that this is necessary.
He's been in Tri-Cities for 2 years. He has a job at the airport. He's handling for United Airlines. So he does have a good job. Doesn't appear to have any other, doesn't have any criminal convictions that he stands there with just the 2 pending cases. And he does appear to be coming to court. He has a warrant.
Mr. Christian, you had the opportunity on the prior assault charge when I did follow the victim's request not to issue the no contact order. And I didn't issue the no contact order. Here we are 5 months later with a similar issues. I am going to issue the no contact order. And under that, this will be a pretrial temporary no contact order. It will expire on August 26, 2022. Under the terms of this order, do not cause, attempt, or threaten to cause bodily injury to, assault, sexual assault, harass, stalk, or keep under surveillance a protected person. Do not contact the protected person directly, indirectly, in person, or through others by phone, mail, or electronic means, except for the mailing or service of process of court documents through a third party or contact by your attorney. Do not knowingly enter, remain, or come within 500 feet of the protected person's residence, school, workplace, or her person. A violation of this order with actual notice of the terms is a criminal offense and will subject you to arrest, You can be arrested even if the person protected by this order invites or allows you to violate the order's prohibitions. You understand that? What don't you understand? You're not to have any contact with her. You understand that? You're not, well, bail set at $10,000 cash or bond. We'll continue this to September 14th, 2020 at 8:30 in the morning. We'll appoint Mr. Libbert to represent you. If you post that bail, you're not to have any criminal violations or domestic violence related incidents. You obey the no contact order. September 14th. You can have a seat. I think the last one, 40. All right. I just need the file. I need that file.
Was that the one?
Yes. Yes. All right.
Ms. Raymond Tate, is that the plan you have?
Yes.
Try to put our other.
All right. All right, with the exception of Ms. Raymond and Tate, the rest of you will be placed in the breakout room. Ms. Tate, can you hear me?
Yes, I can hear you.
Ms. Raymond?
Can you hear me? Hello? Hello? Can
Ms.
you hear
Raymond
me?
and Tate, can you hear me?
Yes, can you hear me? Hello? 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 Are you able to hear me?
No.
Got her name on that. She should be somewhere private where she can talk to Norma.
Hello? Hello? Oh my. Hello?
Ms. Raymond and
Hello?
Tate, can you hear me? She was
Yes, can you hear
confused.
me?
I had a conversation with her. I don't know what's happened here.
Hello? Hello?
Ms. Raymond?
Yes, can you hear me? Hello? Oh my God.
There we go. Can you hear me now?
Can you hear me?
There you go. You were breaking up there for a moment. All right.
Oh my God.
You are here today on allegation of a probation violation. Let's see, it looks like a new offense in Benton County. This is that the only thing?
There's a subsequent offense resolved just last week with an SOC.
All right. Yes.
I did talk to her about the issue. It's a 10-year-old or 8-year-old case. She was supposed to do, I think, 42 hours of work crew, and she completed 20. I asked her about that. She actually thought she was done doing all the work crew, and I moved on to stating her results. She's been position, probation, the prosecutor was 20 days before monitoring closed. I did discuss that with her. She indicates the problem with that is that she has special needs children. She works and she goes to school. It would be difficult to do home monitoring. She indicates she doesn't know how to go about doing home monitoring in that community because she's never been in trouble in that community. She is hoping that you might consider waiving, 22 hours of work per week, since she does reside in Arizona and hasn't had problems with it. If, she needs to do the home monitoring, she understands that.
I'm going to strike the word crew. I get that the reason it's not done is that she just left the state. But under the current COVID-19 pandemic issues, we've terminated work crew until probably January anyway. So I'm just going to strike the requirements. No new offenses. We want to terminate probation.
Yes, Your Honor.
All right, we're going to close probation today. So that'll conclude your case here, Ms. Raymond. You understand that?
Yes, and I just so verifying I don't need to do anything else. We're good.
Yes, that's what
Oh.
the case is terminated means.
Okay, just wanted to make sure.
All right. Thank you. You are free to go.
Okay, thank you.
You're welcome.
Okay.
All right. I have one more case. So, okay.
They're in the breakout room.
Chatting.
Chatting, so this might be an opportune time to take maybe just a recess.
All right. Yeah, we'll take a short recess. I'll be in the jury room. So.
All right, go to recess.
We're on the record. All right. Good morning. This is Pasco Municipal Court. We're here with Ms. Rodriguez and Mr. Sorto appearing remotely. We have our interpreter appearing remotely as well. Mr. Hansen is in the courtroom with me this morning.
Buenos días. Este es la Corte de Distrito, la Corte Municipal de Pasco. El señor Sorto está compareciendo por video y la señorita Rodríguez también está compareciendo por video. El señor Hanson está aquí presente. Thank you.
All right. And I want to thank you for your patience this morning.
Quiero darle las gracias por su paciencia esta mañana.
What are we doing today?
Jenner, this is an SOC matter that Mr. Sorto failed to comply with the hours that he was given due to medical reasons, but Mr. Rio and I have reached an agreement.
Su señoría, este es un caso de un acuerdo de aplazamiento de incumplimiento, de acuerdo de aplazamiento de condena. El señor Sorto no cumplió con sus horas debido a por razones médicas, pero el señor Rio y yo hemos llegado a un acuerdo.
On that agreement, Your Honor, Mr. Rio has asked that his SOC be extended a year and that he no longer has to complete those community service hours.
En el acuerdo, el señor Rio pidió que el acuerdo se extienda por un año y que el señor Sorto no tendrá que cumplir con esas horas comunitarias.
I have communicated that to Mr. Sorto and he is in agreement with that.
Yo le comuniqué eso al señor Sorto y él está de acuerdo con eso.
And just for the record, since we're talking about compliance issues, how about the anger management?
Y solamente para que consten actas, como estamos hablando de asuntos de cumplimiento, ¿qué pasa con el control de la ira?
That was completed, Your Honor, and we did send proof to the prosecutor's office, and I believe probation has that as well. And also the fines were paid.
All right.
Sí, eso se cumplió y mandamos prueba de eso a a la oficina del fiscal y también parece que recibieron la libertad probatoria recibió prueba de eso también.
And just for your edification, Ms. Rodriguez, with regard to reports from medical service providers, we forward all of that information to the prosecutor's office because they're not actually set up formally on probation. It's just a supervision.
Good to
Y
know, Your
nada
Honor.
solamente para que sepa, todos esos registros médicos nosotros se los enviamos a la Oficina de Libertad Probatoria porque porque no están, no es una libertad probatoria programada.
I'm concerned about confidentiality, and since there's not a probation file, all of that would go into the court's file, and I don't want that information in the court's file.
Me preocupa la confidencialidad y como todo eso no es un caso de libertad probatoria, todo el caso se va al caso de la corte y me preocupa eso.
All right, so based on that record, we'll extend this 1 year.
Basándonos en ese recorte, esto se va a extender por 1 año.
And I'm assuming that's 1 year from the original review date of June 16th.
Y asumo que eso es 1 año a partir de la fecha de revisión original del 16 de junio.
Yes, Your Honor.
Oh,
Sí, su señoría.
so the new review date is June 15th, 2021.
June 15th, Your Honor.
Yes, 2021.
Ajá, la nueva fecha de revisión es el 15 de junio del 2021.
All right, Mr. Sardo, if you have any questions, I'm going to encourage you to speak to Ms. Rodriguez about this case.
Ok, señor Soto, si tiene usted alguna pregunta, yo lo animo a que hable con la señorita Rodríguez acerca de esto.
Otherwise, based on the agreement of the parties, this review date is continued to June 15th, 2021 at 8:30 in the morning. You can appear or show compliance by affidavit.
Entonces, basándonos en el acuerdo de las partes, la nueva fecha de revisión va a ser el 15 de junio del 2021 a las 8:30 de la mañana y usted puede registrar su comparecencia en presencia o por medio de declaración jurada.
Is there anything else we need to address today?
¿Hay algo más de lo que tengamos que hablar hoy?
No, Your Honor.
No, su señoría.
Yes. Yes, and for the record, so it's clear, we are pursuant to the agreement waiving any of the work crew hours.
Y para que conste en actas, estamos acordando eliminar las horas de trabajo de cuadrilla.
All right. Thank you. That'll conclude our
Your
hearing today.
Gracias. Esto concluye nuestra audiencia.
Have a good
Thank
day.
you, Your Honor.
Que
Likewise.
tengan igualmente.
All right. In recess.